Welcome everyone. I am Rajeshwari, Assistant Professor in the Department of Commerce from Trinity College for Women, Namakkal. In this session, I am going to say about essential of a valid contract in business law. Now, the following content are going to discuss. They are meaning of business law, sources of mercantile law, definition of contract, meaning of agreement, distinction between an agreement and a contract, and essential of a valid contract. First one, meaning of business law. Before we enter into the topic of business law, we must know about what is law. Here, law means set of rules or rules and regulations made and enforced by the government that regulate the people within a society. And law follows certain practices in order to deal with a crime, business, social relationships, property, and finance, etc. Finally, the law is controlled and enforced by the controlling authority. Now next, meaning of business law. Here, the business law, otherwise known as mercantile law. Mercantile law or business law is concerned with the rights and obligations arising out of mercantile or commercial transaction between persons. Here, the persons which represents individuals and institutions. And the law in respect of the following will be part of mercantile law. They are contracts, sale of goods, insurance, carriage of goods, negotiable instruments, partnerships, and companies. Next, we move to sources of law. The sources of law, which includes English law, judicial decisions, customs and usage, statute law. In this English law, which consists of English common law, equity, law merchant, statute law. Next, definition of a contract. According to section 2, subsection H, a contract is an agreement enforceable by law. There must be an agreement. Such agreement must be enforceable in a court of law. So these are the two conditions which satisfies the contract. Next process, an agreement. According to section 2, subsection E, which defines every promise and a set of promises forming the consideration for each other. Next, promise. Promise means according to section 2 subsection 5, a proposal when accepted a promise. In this concept, we follow agreement equal to offer plus acceptance. And now we have the difference between agreement and contract. Here, an agreement equal to offer plus acceptance, but in a contract equal to agreement plus its legal enforceability. In an agreement, it may be create social or legal obligations, but in a contract creates only legal obligations between the parties. In an agreement, all agreements do not become contracts, but in a contract, all contracts are based on agreements. Here before, we discussed the meaning of contract, and now we move the essential of a valid contract, which consists of the following elements. First one, the first level, offer and acceptance. Here, there must be two parties to an agreement, in that one party making the offer and the other party accepting it. And second level, legal relationship. The parties must have the intention to create legal relationship between them. Then third level, lawful consideration. Consideration means something in return. It may be in cash or kind or in any form as specified in that act. And fourth level, capacity of parties. Here, the parties to a contract must have capacity to make valid contract. And fifth level, it is free consent. Here, free consent means the parties must be free and genuine. And consent means agreeing upon same thing in same sense at the same time. Sixth level, legality of object. The object of an agreement should be lawful and legal. It must not be illegal. Then, seventh level, not declared void. It should be capable of being enforced by law. And next, eighth level, capacity in terms. The agreement should be clear to the parties of an agreement. And ninth level, possibility of performance. The terms of an agreement should be capable of performance. An agreement do not an act impossible in itself cannot be enforced. Then last level, fulfillment of an legal formalities. A contract may be oral or writing. This involves completing a contract or agreement where all obligations we have been fulfilled. And finally, the elements mentioned above must all be present. If any one of them is absent, the agreement does not become a contract. Finally, all contracts are agreements, but all and agreements are not contracts. Thank you.